Hi, I'm Josh Goldberg. I'm a patent attorney and a partner at Nath Goldberg Meyer. One of the questions I've been asked with increasing frequency lately is, how can I get a patent on a method for diagnosing someone who has been infected with the coronavirus? Unfortunately, there's no easy answer to this question, as the law for diagnostics may help you get the protection you are looking for. The US Supreme Court has issued a series of decisions essentially stating patent claims for medical diagnostic methods cannot be patented, as they are considered patent-ineligible subject matter. That is, unless there is something brand new to the steps, equipment, or materials used in the diagnostic method is simply directed to a law of nature. The diagnostic method claim recites conventional techniques well known by medical practitioners. There is no inventive concept that might transform the law of nature into a patent-eligible invention. For example, the patent claim directed to a method of detecting paternally inherited cell-free fetal DNA in maternal plasma is not patent eligible. Even though this method of fetal genetic testing may be innovative, it is currently seen as nothing more than a discovery of a natural phenomenon, the presence of fetal DNA in the mother's bloodstream. So long as the techniques used in the method are well understood, routine, and conventional, they do not add any inventive concept. Similarly, a method for detecting drug-resistant variants of a tuberculosis-causing bacteria using techniques that are well known and routine in the art would typically be directed to unpatentable subject matter. Where the method relies on naturally occurring nucleotide sequences, it does not contain an inventive concept. What does this mean for patenting a method of diagnosing coronavirus, such as COVID-19? It means there are some possible options that may be available to help. For example, if a new technique is used for the diagnostic method, this could be patentable. By now, we are all familiar with the images and descriptions of people having their noses swabbed to perform a COVID-19 infection test. Clearly, nose swabbing is a well-known technique for diagnostic methods and would not be a basis for getting a patent. But what if, instead, it was possible to test a person for COVID-19 infection by having them spit on the same swab, which would then be processed? If this is a technique that had never been used in viral diagnosis before, it could lead to a basis for patentability. Another way of looking at this is, what if you find what that swab is made of impacts the reliability of the COVID-19 infection test? If, based on this research, you develop a swab made of a material never used in such a swab before, this became considered patentable subject matter, and thus eligible for a patent. One other possibility for obtaining patent protection is to combine a diagnostic method with a method of treatment. Adding the treatment step should transform the unpatentable subject matter of a natural phenomena into patentable subject matter, as an additional, non-natural step is taken, the treatment itself. The combined method would be viewed as more than a natural correlation, as a change on the patient is affected by the treatment. Accordingly, while there are currently challenges to obtaining a patent for a diagnostic method for a coronavirus in the US, there are also options that may be available to protect your invention. We remain available at your convenience to review these options with you and discuss what might be the best fit for your technology. We can be found at www.nathlaw.com, or you can email me at jgoldberg@nathlaw.com. Thank you very much.